Hi, my name is Kelli Smithey, and I will be going over the competence to testify in court. So, what does competence to testify mean? It is defined as the ability of a person to have a sufficient mental capacity to perceive, remember, and narrate the incident that they observed. Those who are unable to remember or accurately portray the events of the incident may not testify. In the year 1975, the Federal Rules of Evidence stated that every person is competent to be a witness unless their testimony is irrelevant or likely to mislead the fact finder, or the person is unable or unwilling to promise to testify truthfully. So this is the competency criteria at a glance. They are listed at 5 bullet points. So the first one is the ability to observe the event, the ability to remember the event, the ability to communicate that memory, the ability to tell the difference between truth and falsity, the ability to understand the obligation to tell the truth in court. And under Rule 601, which was previously stated in the Federal Rules of Evidence slide, minimum capacity in each of these areas is necessary, but courts and parties have sought assistance from behavioral sciences when competence has been raised. Psychological research. There are 4 categories of individuals who are most likely to enlist testimonial concerns. These are children, people with intellectual and other developmental disabilities, people with mental illness, and those who have abused substances. Until the 1970s, the law of most states presumed children under a certain age, around 10 or 14, were incompetent to testify. Courts also routinely barred those with significant impairments from testifying. Psychological research, children, and testimonies. So over this slide and the next slide, it will be discussing children and the testimony from their perspective as well as the court's perspective and how they expect it to occur, basically. So the observation part, a child or person's ability to sense events is usually sufficient enough to meet testimonial capacity unless they have a mental disability, visual deficit, or hearing deficit. Young children, however, may have more trouble recalling the events due to their limited ability to process what they have seen. Johnson and Foley found that recognizing complex events such as unfamiliar faces, disguised faces, or complex scenes requires processes that are more likely to be developed with age. A child may not be able to understand what they have seen or fully grasp sophisticated conversations, but they are still capable of registering the event. Memory and suggestibility. Over time, memories can become less clear, making the recollection of events more difficult to testify about. While it does not render a child incompetent, it is noted that they are more suggestible than adults. There are 2 types of memory, which is recognition memory and recall memory. Recognition memory will include questions about whether they can recognize a person or a place, and questions of recall memory will include descriptions of an event, person, or place. There is evidence that children sometimes place familiar faces in events that they may not have been a part of or present in. And the difference between the recall memory of children and adults depends on 2 variables: time and the extent of other versions of the event that third parties have suggested. And that part is the suggestibility issue that is mentioned here. There's a study conducted by Marin and colleagues, and it was found that children can recall events like adults shortly after they occur, especially with recognition tasks, though they do tend to give fewer details. Over long periods of time, however, their memories do tend to fade quicker and become more susceptible to error. Research shows that interviewing children soon after events using careful questioning can help preserve the accuracy as opposed to using open-ended questions. Children over the age of 10 are more likely to show adult levels of resistance, but children under 6 are seen as more vulnerable to suggestions, especially if those suggestions are made by an authority figure such as somebody in court or their parent. Children and testimonies continued. The ability to communicate. Communication is important when it comes to relaying past events. If it cannot be communicated in a coherent, meaningful way, a witness's observation and memory of it are no longer useful to the fact finder. Children can struggle with time, memory recollection, and language used in court. For example, certain testimonies, most notably child sexual abuse, may require verification of the child's comprehension of the meaning of terms and behaviors. It was asserted that children up to the age of 7 struggle to decenter, understand chronological order and its importance, as well as interpreting the actions of others, which could all affect their testimony. However, it was concluded by Schaefer that by the age of 5, children not only understand most of the grammatical rules of their native tongue, but are also constructing adult-like sentences. Courts generally accept these developmental limits and focus instead on whether jurors can fairly assess the child's statements. Clarity can be improved by having examiners use dolls, pictures, and simple language. Moral development, truth and falsity. The focal point of the competence assessment is the witness's ability to abide by the oath. For a child witness, the court would ask if they believed in God and if they understood what the consequences of lying are. Now, children can swear on an oath, affirm, or even sometimes testify without the oath, as long as they show the understanding of the importance of telling the truth. Research has shown that children are not more likely to lie than adults are, and that even preschoolers usually seem to know the difference between a truth and a lie. However, this doesn't mean that they won't be or they can't be influenced by outside influences such as friends, parents, or other adults. The real difference in why kids say the truth matters is that younger kids see rules and punishments as a means of motivation to not lie, whereas older children tend to garner more respect for others. Guidelines for evaluation. Clinicians must address whether they have anything to add to what a judge will discern, such as observation, memory, communication, and moral capacity. The witness's observational skills can be directly assessed, however, if the event took place when they were younger, the information about such skills may have to be obtained from significant figures, such as a parent. Memory of events can be tested by asking questions about recent and long ago events. Communication skills can also be assessed by having the witness recount and describe the aspects of an event that are known to have occurred. The witness's understanding and willingness to tell the truth can be assessed by abstract questions about what it means to tell the truth, followed by requests for specific examples. Assessment of witness credibility. An evaluation of a witness's competence to testify addresses their capacity to observe, recall, report events, and understand the oath. Expert testimony on credibility addresses the chances that statements made by a person found to be competent to testify are truthful. The law on expert testimony about witness credibility. Ethical rules forbid both the judge and the lawyers from expressing opinions in front of the jury about the truthfulness of a witness. Before Rule 608, which liberalized the approach to credibility, was adopted by federal courts in 1975, only statements about the reputation of the witness's truthfulness were permitted. The limitations to this rule include 1. The evidence only refers to character for truthfulness or untruthfulness, and 2. The evidence of truthful character is admissible only after the witness's character has been attacked by opinion or reputation. So this slide is the law on expert testimony about witness credibility continued, because there is a lot of information regarding the law aspect, obviously, since it is court. So the 11th Circuit noted conditions like psychosis, neurosis, neurological deficits, mental deficiency, alcoholism, drug addiction, and psychopathic personality may be relevant. However, such testimony is not routinely admitted. There are 2 reasons for this stance. The first reasoning is that courts may view the credibility testimony as not based on specialized knowledge, which is required of all of the expert testimonies. And the second one is, even if it qualifies, there is potential for confusing or influencing the jury, which could outweigh its value. Expert credibility testimony in 4 recurring contexts. So these are the 4 contexts that you will see them pop up a lot. So the first one is witness mental disorder. So when a witness shows severe symptoms such as like hallucinations or psychosis, like it was mentioned above in the 11th Circuit part, experts may assess credibility and competence. The second one is in rape cases or sexual assault. We talked a little bit about this and child abuse cases, which, spoiler alerts right there, but historically sexist and used to challenge the credibility of a witness, but declined in the 1980s because of rape trauma syndrome testimony. So they were asking the witnesses to constantly recall what they went through, what they saw, and it was becoming damaging to their mental health. Number 3 is child abuse cases. So some courts allowed experts to testify that children rarely lie. However, research shows children can be suggestible and influenced, which falls under the suggestibility influence that we talked about in the earlier slides. And the fourth one is eyewitness accuracy. Experts may present research on perception and memory errors. Courts are divided on this, however, while some allow eyewitness testimony, others do not. Legal strictures on evaluations of credibility. Out of concern for witness privacy, the federal rules of civil procedure only allow mental examinations of parties and only when there is good cause for such evaluations. Courts hold that they have inherent authority to order evaluations when they deem necessary. So good cause may require showing 3 things. So the first is a history of impairment leading to fabrication. The second is fabrication on issues similar. And then the third one is there's no other way to assess the credibility. In civil cases, courts require a showing of a good cause, meaning more than just the possibility of relevant evidence. A good cause showing in this instance might require proof that the witness is known to possess some type of impairment that led to fabrication in the past. In criminal cases, a lesser showing may be permitted, but some commentators argued that a lesser standard is not appropriate. The defendant's request carries constitutional weight under the Sixth Amendment. But there is caution given the weak scientific support and strong privacy concerns. It is argued that with cases such as sexual abuse and child abuse, notions of evaluations can be damaging and discriminatory. So since a lot of this chapter and these pages covered children, I really wanted to focus my discussion question on their perspective in a way and understanding how they are used in court. So my question turned out to be, since children are a part of our most vulnerable in society, does putting them on the stand to testify increase their risk of trauma? And are they sometimes used as a strategic way to win a court hearing rather than wanting to truly relay their testimony to the jury? How could this outlook be prevented, and how are they protected? The media that I chose for the assignment is listed below. So it's basically discussing how children testify in court and how they are protected as they address the court, as well as mentioning the evaluation process they go through and what it means. For references, I primarily stuck to the book. I found everything in there very helpful. And that is it. Thank you.